A prestigious boarding school, a private school, mind you, rejecting a teenager after finding out he is HIV positive. Now, the school says it's in the best interest of nearly 2,000 other students who board there. But is this against the law? Here now, defense attorney and former prosecutor David Schwartz and Fox News legal analyst Lise Wheel. Is it against the law, Lise?
Yes, it is.
Why?
Absolutely.
You sure?
This is a private school. I've got you that. But they're still covered by the Americans with Disabilities Act. And this child does have a disability, but it's not one that would be of harm to other kids. The medical experts don't say it would be a harm. He's taking 5 pills a day to control it. He's going to the doctor 3 times a year, the hospital. And they made no individual assessment about this particular child and his danger. In fact, what they told the mother was, we don't take kids like that.
But you know what? I read the ADA as well, and it says private schools may exclude if they do an individual assessment of the applicant. I interviewed the plaintiff's attorney, and here's what she said. Here it is.
Is there something about him that makes them think he's a risk? Is there something in his history? Is there something in his behavior? Is there something particular to him? But they didn't do that assessment. They didn't ask. They don't have any of that information. They just declared he was a risk.
David, they never even spoke to the boy.
You don't have to, Greg. To do this assessment, you don't have to speak to the boy. You have to do an assessment. You have to assess the medical records. You have to assess whatever evidence is available to you to make this decision. This private institution made a policy decision here to protect the other 2,000 kids. Now, maybe there was no moral justification, but there's certainly a legal justification, and that's all we're talking about, whether they had the right to do it, Lise.
If they had checked the records, the medical records, they would have seen that he had a small viral load. That's what it's called. And he's not a danger. He's not. And they can't communicate this horrible disease unless he has
just because he is a low risk, because he has a low viral load, that does not mean, Lise, that he could not through sexual contact.
Through sexual contact. All right, we just got to the point of it here. Doesn't the school have an obligation to make sure that there is no sex? These are 13-year-olds.
I asked the school about that. Here's Connie McNamara, who's the spokesperson for the school. I talked to her on Friday. Here it is.
As any parent watching your show can tell you, you know, teenagers, you just can't predict what they're going to do. And when you can't be 100% sure that this child will not engage in sexual activity on campus.
Lise, the point is that even the best security, the best efforts to keep boys and girls away from each other at night, sneaking off at a boarding school, you can't eliminate the risk. And elimination of the risk is what the ADA says.
No, it's not elimination of the risk. They've got to show clear and present danger of risk, and that's not what they've shown here. Also, by the way, Greg, by that logic, by carrying that forward, you would say to the school, oh, it's okay if our kids commit statutory rape because it's a crime.
Greg, I think what we're missing here is reasonableness. It's not what you think, Lise. It's not what I think. It's not what you think, Greg. Did the administration act reasonably under the circumstances? Did they make a reasonable decision? And based on the evidence, they did make a reasonable decision. And that's what the court is going to say. You may have made a different decision.
Here's the problem. Page 4 of the lawsuit right here. There's a claim that a representative of the school, before the kid ever even applied at the school, told his case manager at the hospital, oh, quote unquote, we don't take kids like that. If that is true, and if the plaintiffs can prove it, there was no individualized assessment, and he was not. He was violated under the ADA.
Well, that may be true, and that'll be a question of evidence. I think the school denies that conversation.
No, they said we cannot confirm or deny.
Or deny.
Well, then that'll come out. Here.
But the bottom line is they could take the medical condition that the student had, along with the individual assessment, along with analyzing the records, and they could reasonably conclude that they cannot protect the other 2,000 students in the school.
No, and they did none of that, David. If they had done all of that, if they had met with the kid, then I've seen at least what the plaintiffs are saying, and none of that was done. Instead, we don't take kids like that with HIV.
You know, it's a tough situation, and our hearts go out to the little boy, 13 years old, HIV. The good news is that he's very low risk. He's doing well. Our best wishes to him. All right, Lise Wheel, David Schwartz.
Thank you.
Interesting case. Thanks. Heather?
Well,